Over to Shibani Sagar.
Mitali, thank you for that introduction. I am been invited by IP leaders and by CII to share my experience and take you through clarifications on this new legislation that has been passed in 2013 after about 16 years of some ambiguity on how to actually provide neutral and gender protective workspaces for women. This law is protection of women at the workplace, and it was prompted by many instances of and cases where women have faced sexual harassment, amongst other discrimination and workplace inequalities. That being the background of the law, I'm going to invite Abhyudaya to take us through the presentation, and I will be clarifying and expanding on the issues of why this law has been enacted, what is the purpose for this legislation and the rules, and how companies are expected to implement this law, and how and the challenges that may be faced in the implementation of this law, how we can help to clarify on some of those challenges. Abhyudaya, I invite you to just take us through the introduction to this law and the presentation.
Thanks, and thanks, Mitali, for the introduction. Hi, everyone. So today's presentation is going to be divided into 3 parts. We will have a very quick introduction into why the law was enacted, and we will move on then to the key obligations that employers have under the new law. And the third part is what are the key challenges they are facing. These are simplistic challenges in implementing the obligations. We are not going to get into hyper-technical questions at the moment. We are going to have more webinars subsequently where we will discuss these questions. So for now, let's discuss some of the major gender-specific inequalities that we have had and which manifest themselves in workplaces very commonly.
Right. So
over to you.
Yeah. I hope we're sharing the mic and I'm audible at this point.
Yeah, yes, Shibani, you are audible.
Excellent. So, thank you. So, in context of the workspace, in the corporate workspace, one of the often referred to instances is of the glass ceiling. It's a documented fact, it's an often discussed fact that as women have largely joined the organized and of course also the organized sector, they form one of the largest portions of the unorganized sector. In the organized sector and therefore trickling down also to the unorganized sector, there exists what we refer to often as the glass ceiling. And from the top-down approach, this is where the inequality possibly starts, where there is more, there is a balance which is tilted towards the male predominance in the higher senior executive areas in most of the corporate sector. This in itself has propagated certain inequalities which have led to the instances of sexual harassment. Before this act was enacted in 2010, on a survey that was conducted over this sector before finalizing the legislation, which had a demand for the past 16 years, it was observed that 88% of women have faced some form of sexual harassment. It's an observation. If there were larger numbers of women in senior executive positions, those companies have in fact been able to balance some of the requirements of women, where HR has had more exposure to hiring women and engaging with women and dealing and addressing issues of women. There have been lesser instances of sexual harassment. Gender discrimination against women. This is something that is often spoken about. It doesn't need a statistic. Women have joined the annals of society in the workforce, in politics, in social life at a delayed time. Their entry has been slowed, also owing to traditional work role structures, and currently there's no legislation, there is no provision, and there is no requirement for even something as equal work for equal pay. Even the United States has not been yet able to enact a legislation that requires equal work for equal pay. The discussion on the requirement and the policy belongs somewhere else, but the fact remains that largely, even in the corporate and organized sector, there is no equal work for equal pay. And that itself is the largest gender discrimination. In different industries and different areas, depending on the roles of men and women in the corporate structure, there is a bias towards men in senior strata for promotions, for remuneration, compensation, and also for hiring. Of course, these have traditional reasons, and these have been debated before legislature, and those traditional reasonings have increasingly stopped to exist as the workplace is moving towards being more neutral. Of course, maternity and career growth have also been seen as hindrances for women to be in positions of power. However, women are continuing to perform the work, take part in corporate decisions, be in fact as productive as the rest of the workforce, however are still facing biases in all the areas of traditional corporate structures as well as manufacturing, unorganized sectors, and today in the emerging technology and shared services space. As it were, women are being hired in large numbers, since the numbers for the shared services spaces and the new technology businesses is pretty high. Also, there are many areas in which it is increasingly seen that the requirement for women is high. However, they are still not in a position to demand the same perks, the same treatment, or the same career growth paths. In this background, and observing the inequalities which is leading to an unequal workspace, the legislature has finally passed this act in 2013. Also in the background of increasing crimes against women and the fact that women are in the workspace and are demanding what is their rightful space and are unable to demand that rightful space and have socially and traditionally been perceived to be the traditionalist role, that women are unable to actually bring forth issues that are not from the workspace, that are not workspace issues. And therefore, this law was seen as required, and it is also based on international laws and international workplace methods and the outlook that the international community has had towards the development and empowerment of women in the workspace. Okay.
Thanks, Shibuni. Do you have any thoughts on how the law has, evolved since Vishaka?
Well,
there was this the Supreme Court judgment in 1996. Yes.
Yeah. So it's relevant while we're discussing the background of why we're at this law. Vishaka was a judgment in 1997, and in fact, it wasn't from a traditional workspace, and it's not the facts of the case are not relevant. However, the Supreme Court at the time, recognizing by 97 we were already half a decade into liberalization and seeing the increasing participation of women in the workforce, had laid down principles, in fact, which directed companies to make provisions for women, for women in the workplace, for them to be able to participate in the workplace without any inequality or without any discrimination. These were laid down in the form of as part of a judgment, and laws that are laid down as part of a judgment in India have the value of law. However, they are not mandatorily followed since they have not been passed by legislature, and the outlook of companies can be sometimes only very proactive companies actually end up trying to follow the trend of what a legislature is saying. Today, legislature is laying down law with the intention that that is the trend of the court, that is the trend of the justice system, and that is how we will be looking at crimes against women or the workplace. However, during the course of the last 15 years during which Vishaka has existed, companies have not in fact proactively taken up the mantle to follow Vishaka. Unless those companies have been exposed internationally or required under international laws or their respective jurisdictions like US law, UK law, the European laws, required to in fact provide these mechanisms within companies, most companies were not looking towards following Vishaka. Now, Vishaka is an often thrown around word in this context, in the context of sexual harassment. So it's important to understand the background of Vishaka because that was how a judiciary has before seen this law. Today, of course, a case will be looked at in perspective of the existing 2013 enactment. However, Vishaka becomes relevant as it clearly laid out very simply what was required of an employer. Now, in its simplistic view, the employer was required to basically provide a safe working environment at the workplace, and if there was sexual harassment, make sure that the outcome or the penal consequence of the sexual harassment was displayed to the company, so there was an educative value to it. Now, some companies have taken advantage of this and are way ahead in their having been able to provide neutral workspaces. But clearly, after Vishaka, there wasn't a rush towards actually forming committees unless it was a reactive position. Most companies have actually formed a committee after an act has taken place. And this is not really either, we wasted 15 years, or rather, we could have used these 15 years to in fact go through the education process of how to provide these committees and how to provide a safe working environment. If you see, even recently, last year, there were cases which very clearly pointed out that the courts themselves, which are not a traditional workplace as they are seen at today, but even government departments have not in fact taken cue from Vishaka and made these provisions. So since Vishaka was a heads up 15 years ago and companies had every reason to in fact either form a committee, and we will come during this presentation to why we refer to committees, which is a requirement today of the law. However, basically make provisions for a safer workspace or for a gender neutral and productive workspace. The companies that have taken cue from this and have been able to provide it have in fact done most of the actions which are today now mandated, which is forming committees, providing trainings, having a complaint mechanism. Companies like international companies which have been at the forefront of providing compliant workspaces and governance have in fact been the beacon to show the government what could possibly be part of the law and which are the structures which can in fact ensure a gender neutral workspace and a productive workspace which is mitigating sexual harassment and other workplace inequities. So today, also there is, before the law was enacted in 2013, we have the background of Vishaka, a case that had taken place and prompted the judiciary to in fact lay out, outline a requirement and necessity for and guide employers and institutions to in fact provide a safe workplace and a productive, proactive work environment. In that background today, the structure of the economy has changed. We have younger workspaces, we have new structured organizations, businesses and forms of business that didn't exist before, which require not just a contained workspace, but in fact workspaces, for instance, in retail. You have many retail outlets which belong to one organization. However, people that are hired by that organization and are employees of that organization continue to work in spaces that are outside the workplace environment. The instances of interaction between employees and third parties, that is the general public, have increased. The instances of interaction between employees and different forms of employees has increased. There is different forms of employment that are adopted today. For instance, consulting, using contractual employees, having interns. Of course, I know that there's a nuanced understanding of who all will be in fact covered by this law. But these are the requirements that have prompted a law and rules to be laid out that actually cover the entire gamut at which you can have workplace inequities and instances of harassment. Also, there's an increased awareness of workplace rights, with an increased awareness of workplace rights from the fact of the internet, the fact that men and women alike are more aware of all the rights under which they are employed, and in the background of increased criminal activity, increased social interactions, there is an awareness of what rights are available to a person that is either employed or is otherwise servicing either an industry or an organization or an employer or a corporation. In this background, this law has now been enacted, which has a number of requirements that are placed on the employer to ensure a safe workplace. Okay. Now, the awareness of this new law on sexual harassment is imperative for anybody who's working in the organization. Often because of lack of awareness or lack of gender sensitization training, employees or employers, managers, people in different grades may engage in acts or say things advertently or inadvertently without realizing that they amount to sexual harassment under the law. Currently, there is the requirement for the employers to draft and implement a suitable sexual harassment policy, and also to include suitable clauses in employment contracts and service rules which will prohibit sexual harassment. This sexual harassment policies are outlined, and the requirements of what will form the basis of sexual harassment policies today can be basic policies or can be comprehensive policies. Different organizations have an outlook on this depending on how they have, what's their outlook towards compliance, what is the outlook towards working rules, and also how you're providing standing rules according to standing orders or following the standing orders. Large organizations like institutions, as education institutions, hospitals, are actually formulating comprehensive policies. Since comprehensive policies cover the many aspects of interaction between employees, employers, employees and third parties, employers in service areas, employees and clients, employees and third parties being serviced by the corporation. The policy is a requirement. It can be drafted taking into account the requirements of the industry. Policies have been drafted. There are draft policies available to most companies, which can, I'm sure CII is also looking at providing support and assistance to its members to understand policies. However, in my experience, policies are crafted with the basic ideology in mind, however, keeping in mind what the nature of the industry is. If the nature of the industry involves different points of interaction, or the nature of the industry involves different instances of employer and employee relations, keeping those in mind, policies are drafted for that industry. The employer is also required to create an internal complaints committee. Now, a complaints committee is a committee of people that basically provides the first point of contact for somebody that is within an organization to be able to bring up the issue or a complaint within the environment of the workplace. The complaints committee has been seen over time and as experienced by corporations that have in fact put these into place as a very important part of containing workplace harassment. This is the first instance at which you can look at a complaint and value it for what it is in context of the workplace itself, in context of the industry, and in context of the actual circumstances in which employees are working along with each other. Currently, the requirement in the law is for every office, also every branch and location which has more than 10 people working to have a workplace committee, internal complaints committee. There are questions around what the viability and possibility of in fact creating these committees is. However, the idea behind having a workplace committee is predominantly to have a committee function somewhat like an ombudsperson. An ombudsperson is a non-partisan complaint receiving authority that can in fact receive a complaint and respect the confidentiality of this complaint and look at a complaint keeping in mind that that complaint needs to be addressed while keeping the productivity and the continuity of the workspace. The idea of having an internal complaints committee also addresses the issue of being able to look at a complaint for its integrity, for its rationale, where it's coming from. Does it in fact amount to a harassment? Is it something that is disrupting the workspace? A lot of these issues may be contextual, and an internal complaints committee is in a better place to in fact address these issues than have a criminal complaint which will in fact address the larger issues of society and potentially address penal consequences, but may or may not have all the tools and the implements to be able to look at the issue and address the nuances of the issue and be able to determine whether in fact there has been a harassment. Now, a complaints committee, the requirement of the law is a complaints committee must comprise of a minimum of 4 members, of which 50% of the members must be women, and one of the members must be either a a person who's familiar with issues pertaining to sexual harassment or is either from an NGO or a women's organization. It requires one senior level woman employee from the organization and 2 employees from that workplace location. Companies have been able to, although this is not advice, this is more an idea of understanding how complaints committees are in fact formed. Companies have been required, if they cross a 10-member a 10-member workforce in any location, to in fact have an internal complaints committee to which any woman who has a complaint of harassment can refer her complaint. In the absence of an internal complaints committee, an employee can approach what is the local complaints committee, which are currently, after the law has been enacted, still being set up. Now, for a corporation, keeping in mind the fact that the idea of this internal complaints committee is to have a mechanism by which you can in fact address issues and address issues in context and be able to address issues at the right time, address issues which may or may not amount to harassment, which may amount to harassment that can lead to an incident having further consequences, will be by itself defeated if employees are required or find the necessity to in fact go and put themselves to the criminal to the criminal process, to the criminal justice process, as well as or otherwise approach a local complaints committee. It is beneficial and better structure and addresses the issue more squarely to in fact have an internal complaints committee which can look at the issue and address the issue for its merits and be able to in fact provide appropriate interim measures as well as provide an appropriate hearing and be able to collect evidence and be able to address the issue keeping in mind the nuance of the industry, nuance of that office itself, and an understanding and sufficient knowledge of the facts and circumstances of the case, while having an external member who can in fact lend their expertise in looking at this issue, either lend their expertise in looking at the gender sensitivity of the issue. So where there are a very small number of women senior level employees that can in fact partake in the committee, an external member does lend some element of understanding what potential gender issues have not been looked into or are not in fact being attended to by the current, by the existing management or by the existing personnel that are setting up the mechanics for conducting business. The other expertise that an external member can in fact provide is the requirement of the law for the conduct of these internal committees is quite elaborate, and a basic understanding of rules of evidence and rules of in fact conducting an inquiry, or a maturity or experience with having conducted these inquiries to in fact arrive at an appropriate finding, and thereafter after the finding to arrive at an appropriate mechanism to in fact address these issues would be lent by having an external committee member who is familiar with issues or familiar with in fact the substantive law that is applicable, and is familiar with the procedure which in fact leads to a fair and equitable hearing in which the complaint can be addressed for what it's worth. So these complaints can sometimes be addressing issues that may or may not in fact amount to harassment. Knowledge and experience of whether it amounts to harassment lends some credibility and also lends integrity to the process. Knowledge of what is the appropriate mechanism to address what could amount to sexual harassment comes from both experience and knowledge of gender issues, as well as issues that routinely may come up in a corporate structure. So in my experience, I've been a counsel to companies, and I have been required as a lawyer to in fact conduct inquiries for other companies merely on account of having the knowledge, one, of the law, and two, of the procedure by which you actually lead an inquiry and lead evidence.
All right.
Yeah.
Thanks. So Shibani right now explained the value that can be added by having an external member on the committee. Of course, it is a mandatory requirement under the law, but there are certain skill sets which an external member always brings in. The other issue that always arises, Shibani, with respect to the external member, as you may already be familiar, is that that organizations tend to perceive that they must be from an NGO necessarily, or from some kind of a women's organization. What is your view on that? That's not written under the law.
No, it's not a requirement under the law. As I was trying to elucidate in what's required of a committee, why do we have a committee? The committee is the first port of call when there is in fact an issue. When you refer an issue to a committee, when there is a small working environment, it is not always possible, one, with your access to the law, that you should be able to go and make a police complaint on something which may or may not actually in fact amount to a breach of the law. Therefore, you have an internal committee. An internal committee should require, even under standing orders, if you have even say an ombudsperson or other compliance process, you would form committees which actually have the ability to address the issues that are brought up in front of that committee. Keeping that in mind, the requirement for an external member was mandated by the government in this legislation as well. The external member lends, one, credibility to an investigation process that may or may not be biased towards the senior management, or may or may not be biased towards a gender or to a class or to a caste, and having an external member lends that. Choosing an external member from either an NGO or a women's organization was a suggestion given by the government, since the impetus for this law came from protection of women. Corporations have in fact hired people with HR backgrounds, in a large number of instances lawyers, in a large number of persons trained in the law, so that they can lend their expertise in how in fact to conduct an investigation. We call this an investigation. It's in fact at the first instance an inquiry. It's an inquiry to look into, is the complaint a complaint that is valid? What is the validity of the complaint? What is the fallout of the complaint? And thereon collect enough sufficient information, which we as lawyers of course refer to as evidence, but it's evidence which lends to proving or disproving or being able to balance the convenience of understanding the complaint. So the whole idea of having a member outside is for addressing these three issues. One is gender sensitivity. Two is the expertise of the substantive law, so that you are not running amiss the law. And third is to in fact have the expertise of being able to conduct an inquiry. And maturity does not necessarily have to be lent to somebody who's outside the corporation or the organization. However, a certain distance affords, a third-party distance affords that maturity of having handled investigations, inquiries, and being able to come to a impartial decision on these. So it's not skewed only towards NGOs or women's organizations. In fact, it should be for a corporation somebody who can lead these, can help the corporation address the issue squarely, and has the ability to look at it from a third-party point of view in order to be able to see that after an inquiry is over, you in fact have to go back to business. A company has to continue its business. In every single inquiry, you do not overstep your limit and in fact be able, so even the penalty or the punishment or the finding of the sexual harassment or the the act which may or may not have amounted in fact to sexual harassment, you need to have an outlook as to how to contain it in order to make sure that you are moving towards a better workspace. The idea is for a third party to be able to impart that to a committee.
All right.
Yeah.
So these were some of the roles of the external member. Yeah.
Sorry, we just skipped an important part on the question,
All
which
right.
is one was you need the policy, two is you need an internal complaints committee, and three you need to perform necessary compliance requirements, which is the company needs to publish notices which inform the employees of the policy itself, of the consequences of harassment, and of the constitution of the ICC. Now, companies are not required, in fact, to write down consequence of harassment as in you will be asked to leave your job or you will be suspended or your pay will be cut, but generally outline that there shall be consequences because each consequence will depend on the circumstances and on the findings of the committee. Companies are also required to submit reports on the implementation and on any interim measures that have been taken by the ICC. These are mandatory requirements by the law. Currently, companies that are actually providing them are also requiring to provide them where instances have in fact been large enough for it to amount to a criminal inquiry. And the reporting of these becomes relevant and important even for a company to do so that they have, one, are seen as having complied with the law, two, have in fact put on record what the findings were at the first instance on the ground, which is exactly where the complaint has actually taken place. Sorry, moving on, Abhyudaya.
Yeah, Shibani, there is a question which is on the senior woman on the internal complaints committee. She's the president, right? So the question is, how senior should she be? Now, there is no requirement under the law of a minimum level of seniority, but any thoughts from you on that?
So, the internal complaints committee, coming back to, I realize that we're also going over this in a presentation format on mute. It's actually these questions that are welcome because they clarify your issues around how and what is the purpose of the committee and with what intention you form that committee. A senior woman employee could be sometimes, I've only heard of instances, I personally haven't been on a company where there's only one employee, but sometimes there is just one employee. So whether she's senior or junior, she will possibly be required to be, or you will be bringing in an external and then having them familiarize themselves with the company or take a position within the company so that they can in fact fill this slot. The seniority of a woman is on her understanding of the business and understanding of by the virtue, the reason that there's a requirement for women is of her understanding of women's issues by virtue of being a woman. So there is no mandate from the law. However, if women are in a position that they're much more junior, and that is something that we have in fact done, then find a reason to send women that are from a junior place, in fact, involve them in the process and train them in order for them to be able to sit on these committees. That training becomes imperative, and training along with experience is what allows women that sit on internal complaint committees, or as we call them, gender committees, to be able to address these issues and to be able to address them within the company, and of course from there on be able to address them on a committee mechanism.
Okay, so as a matter of practice, I've seen some organizations appoint, a managerial level, a woman in a managerial level position. Like it could either be on the board, or if it's a partnership firm, like a law firm, it could be a woman partner who is the senior most woman in that organization. And if she's the president of the complaints committee, and assuming that the organization has multiple offices, so they have to constitute many committees. So this senior most woman would fly down to each of the internal complaints committee meetings if required. That is how they are doing it. Although there is no mandatory requirement of a physical presence of the external member, but this is how some of the organizations are implementing it.
Right.
At the same time, if you have a woman who's a CEO, now you may not want the CEO to be, part of the internal complaints committee. So that's the practical issue here. In that case, maybe someone less senior might equally well be a president. No? The CEO may
I
not
would
have time
encourage
for
companies. Sorry to.
Yeah, please,
I would encourage companies to, in fact, train women that are heading for senior level positions, because it is one of those. It is one of those avenues which, in fact, creates an impetus for a woman to, in fact, train herself for a managerial position in a regular corporate. Now, every corporation has its own challenges. Of course, the technical requirement of the job itself may or may not create a manager level position. However, having a mid to senior level woman employee as a member of the committee would suffice, as far as you invested sufficient time and training in training up that woman to understanding issues of gender. But being a woman, you understand some issues. However, being more exposed to issues of gender, more exposed to issues of corporate interaction, and understanding issues around a corporate structure, around promotions. Women themselves have not participated in these acts and therefore are not available or actually able to take a call on them. And this is an investment that is worth the time of any organization, as it would address this issue as well as address the issue of promoting a neutral workspace. And then, of course, training in areas of investigation and inquiry and leading evidence, and being able to take a decision based on these would be very effective and would be very useful for companies.
Right. There were a couple of other compliance requirements which we couldn't go through, but they've been on the screen for a while. So I hope all the participants have had the opportunity to go through them. Yeah, Shibani.
I can address them really quickly. One is, of course, you empower the ICC, which we've discussed, to conduct the investigation. The ICC needs infrastructure, which is infrastructure requirements and administrative requirements. The other is set up systems for cooperation amongst various departments to facilitate resolution of complaints. Now, we take them for granted, but there is a requirement to collect information, collect data, collect the communication between employees. All these amount to evidence, and all these amount to actually forming part of the investigation and inquiry. You will also require to have witnesses, and the fact that these should and must be, in fact, conducted in a privileged and in a confidential manner is something that committees learn to do and should be actually instructed to do, because the outcome of a hearing, the whole idea of having an internal complaints committee is so that you do not disrupt your work structure, and you are in fact able to address this issue before it starts disrupting the workplace and relationships within the workplace. So basically to enable employees to be able to attend these as witnesses. Also, sensitizing employees about their rights against sexual harassment. This sensitization is by putting up notices and conducting trainings. It's really one of the most important things is making employees aware of the law, making employees aware of what is required of the law, both male and female employees, since this law requires and actually protects female employees from workplace harassment. Many companies, on this note, I must point out, have in fact provided gender-neutral policies. However, the requirement of the law requires you to have a mechanism where a woman employee may complain of sexual harassment by a male employee. And these instances of what amounts to harassment, what in fact does not amount to harassment, so there is no misconcept and it is not a misuse law either. To lay out these nuances, the crux of this lies in the training that is imparted to both the employees, the senior management, and the internal complaints committee. Sensitizing employees about the rights against sexual harassment can be done by way of publication, can be done by way of notice, can be done by way of real-time trainings or internet-based trainings. However, the fact that somebody has engaged with the employee would give them the right information. Otherwise, you are subject to information and the amount of information that is in fact provided to you by media or by third-party interaction, which may or may not mislead employees to actually understanding what the policy of sexual harassment is.
Right.
Currently, this law has these major 6 requirements of the employers, and employers that do not comply with these can be penalized for their non-compliance with a fine of 50,000 rupees on each instance at which the non-compliance is found, which can be found by a routine check or by a complaint from an employee. Repeated non-compliance can also lead to the cancellation of a business license. This in fact is a larger penalty which corporations should be careful of, and the fact that the compliance requires mandatory things, mandatory structures and trainings and materials that in fact can be provided by every employer right at the outset as part of their standing orders and as part of their rules, should encourage employers today to in fact have proactive policies, proactive trainings, and proactive communication with the employees.
All right.
Because, yeah.
So thanks, Shibuni. Now we have just gone through the outline of the responsibilities that that employers have under the new law. For some of the responsibilities, we have gone into a fair level of detail. So I think it will be a good idea if we go through a quick, take a quick relook at the challenges that they face in implementing each kind of responsibility. Wherever you have already gone through, you've already explained something in detail, you could always point that out. For example, here you have already explained what are the challenges in creating an effective sexual harassment prevention policy. But any additions to what you have already said earlier are most welcome.
Okay, to repeat my point, an effective sexual harassment policy should look at the industry, should look at the realities of what that corporation, what the business of the corporation is, and the instances of engagement with within the industry itself with third parties. A comprehensive policy is advisable, a policy that squarely looks at, which also envisages what, in the experience of that organization or that institution or that area, what are potential areas of discrimination or potential areas of interaction that may or may not lead to instances of sexual harassment.
Right.
Whether a policy informs employees of the confidentiality or interim measures, I think everything that is the basis of this policy should find a place in that policy. The law has some nuances which have been questioned. However, the law has very squarely provided for things that in fact will lend to being able to have a neutral workspace and a workspace in which there are less instances of harassment and less instances of allowing any member of the workforce to feel that their response to an advance or a sexual comment or a sexual act should in any manner affect their job, their productivity, or their advancement, should be squarely addressed in that policy. So a comprehensive policy is what my advice is to any corporation.
I had a small question on this. Sorry to interrupt you.
Not at all.
So sometimes there are issues like, say, the ICC is empowered to award compensation in case they find somebody guilty of, committing sexual harassment, and this compensation will be deducted from the person's wages. Okay.
Right.
Now the point is, for these kind of situations, to you, the compensation metrics, for example, will vary for different industries, and also depending on who the perpetrator is. If it's a senior level person, you might want to award a higher level compensation, depending on the perpetrator and the victim. Now, how do you go about establishing criteria for these kind of incidents? Do you put them in the sexual harassment policy, prevention policy, or do you simply, have some kind of a training program for ICCs where you set these metrics, or do you leave the ICCs free to decide whatever they feel is appropriate in a particular case?
It's a really good question, because this has in fact come up where the compensation is preferable to in fact removing somebody from their job since it didn't amount to it, or a transfer. In my experience, this is not something that requires to be in the policy. This is something that in fact is based on the facts of a case, and the training that is imparted to an ICC, and thereafter the experience of the ICC would be a more likely acceptable place for this decision to be taken. What is the compensation? Should there even be compensation? Sometimes compensation is not in fact the appropriate measure to address the issue. Just like sometimes removing somebody is not the appropriate measure. So really this being within the training and within informal rules of the ICC would be a more appropriate place to decide what and how the compensation should be. Yeah.
Right. And employers could also consider maybe having some kind of a rule book or a practice, standards of practice for ICC where they have some such kinds of principles laid down.
Very broad-based principles which in fact govern how an ICC will conduct itself is advisable for any company to have. This is what experts actually lend to. This is the expertise that is brought in by a third-party expert, which in fact has the ability to inform you and advise you and potentially highlight or red flag issues and assist you in creating a rule book that gives at least the ability for a committee to function impartially and not pressurized by either the seniority or the placement or any other specific subjective criteria of a complainant or the accused. So generic rule books that in fact cover the conduct of an ICC are advisable. There are no generic rule books even in a court of law. The court of law follows what you call precedent and follows equity, which is one of the main things that you start when you have a committee that is functioning with a purpose and with the objective of creating a neutral workspace and allowing that workspace to have allowing that workspace to be gender neutral, caste neutral in general, which then allows for there to be no workplace harassment, would be something that would be a part of the training, and the rule book should really be more around nuances and rules that actually govern the form in which an investigation takes place, the form in which you can actually introduce evidence, so that there are no differentiation between one and the other that allows for more complaints of inequality.
Right.
Yeah. So other challenges, as you said, there's a challenge to create, we've already covered this, the creation of ICC.
We've already discussed this.
We've discussed this.
There was something, I had a couple of questions on the external experts bit. You know, something about, let's say, how should they, you know, what should be the terms of engagement with an external expert? Okay, currently what is happening is that for training the ICC, the level of expertise, and even for sensitization, the level of expertise required is very high. Okay, which was not the case earlier. When the Vishaka judgment was in force, you would just have some kind of a preliminary training on what constitutes sexual harassment and how to go to the ombudsman. But now a lot of the terms have got a technical meaning. They have specific definitions under the law. So a higher skill set is required, and then correspondingly the training also has to be more detailed and more effective. And it may not be enough to, you know, just give a simplistic training to employees. With that in mind, how should the terms, so organizations are looking for external experts and they are unable to identify the terms of engagement, you know, okay, should we engage them? What is the model, you know, is this a, should we ask the experts to train also? First port of call is they want the experts to do everything, which sometimes becomes a problem because the expert is capable of sitting at the hearing maybe, but not, or maybe vetting some processes of the ICC, but not helping the employer in every kind of organizational compliance, you know, not in every kind of sensitization. So will you be able to throw any light on this point?
So you see, the law is it's a very proactive law. Now, as a responsibility, the responsibility lies on a lot of us that are attending this call. There are 160 people attending this to understand what the law is, so that they can in fact take this law back to the corporate and back into the industry. And then there are experts like lawyers, women's organizations, NGOs, people who have in fact led evidence, people who understand these issues. I think at some level, at the outset, it will take a certain period of time before the industry can understand and accept how this in fact works. We have not had an ombudsperson process as a mandated process under Indian law over time, and some companies have in fact set up their own processes which have all these principles of natural law, principles of equity, allowing for a hearing to be heard within the corporation, to be heard by a member of your peers. Now, the same way, getting an expert covers 2 to 3 things. An expert, in fact, can either come and sit on the committee and help in the structure and form of the committee and the leading of the inquiry and the investigation and the various factors that comprise an inquiry and investigation. Experts can also lend their expertise to doing something called case management, which is where there is instances of many different kinds of workers, that is both blue-collared workers, white-collared workers, consultants, advisors, and many interacting with each other. Corporations take the view that they would rather have an expert which is on a retainer basis while they train up the internal complaints committee, so that they are not in fact exposing themselves to areas which they do not understand and which can amount to criminal issues. So experts can also be hired or retained on that basis. Now, the law requires it. The reason the law requires this is the law's expectation is for corporations to in fact be able to address their own issues and to address that issue in a closed door environment under confidentiality and be able to provide a productive workspace without disrupting the whole workspace because there's a complaint. I'm going to just give you an example of this. So yes, there is an issue in fact getting experts, but experts can today be chosen from many areas. There are experts, there are law students who are experts in being able to advise you on how to in fact when I say law students, I don't mean first year students, I mean interns of law who in fact have been able to provide the language for a policy as that is the drafting that is available to them and they can vet it. And going up to a seniority level of experienced compliance officers, HR officers, lawyers, lawyers that have worked with women's issues, non-lawyers that have worked with women's issues, who are lending their expertise in order to be able to train people, in order to be able to assist and to be able to give the form of assistance that they in fact are available for. So if you're only available to in fact conduct an inquiry and then take out a report and that's all a company needs from you, then experts lend their expertise to that. However, experts and training organizations as IPDers are required to in fact be able to assist companies to get their information dissemination, the policy itself, and the working of the internal complaints committee to a certain standard with the help of this entire range of experts that are available. Does that answer your question?
Yeah.
Okay. So the compliance requirements do require in-house
Yeah.
legal training. Now, the training that is required to be given is in different forms. The employees need to be trained and notified to the level of understanding what their rights are. Employees are not required to know it's a lot of knowledge and time and expertise. An employee does not need to know how to conduct an investigation or what the rules of an investigation are. However, ICCs are required to be trained in the mechanisms of investigation, and senior level management are required to in fact be trained for more social and acceptable corporate norms that in fact allow this thought process and the existence of this governance requirement and overall compliance, the vein of compliance that runs through a company. Senior level management are required to be trained in that manner so that they are in fact themselves function as trainers. Very successful companies like General Electric have in fact been able to have the lowest instances of any harassment and have led trainings and models of training simply because they've made every single employee accountable, responsible, and cognizant of what is required of the company, of what is the baseline of the company. So apart from just in fact complying with the law, you're also creating an environment where you are aware of your rights and you're aware of conducting yourself within your rights. I think there's a challenge also in how to measure compliance periodically, and companies do different things for doing that. I mean, there are large companies that in fact have audits. There are companies that in fact have annual annual department-wise trainings with an expert that comes in from outside, as an external expert, in compliance in general, in gender sensitivity. Companies are looked to in fact encourage these forms of engagement with their employees.
Right. Shivani, you just mentioned briefly that at GE you had very low levels of sexual harassment, within the organization, which I just want to put an sort of Indian perspective, to it, which is it's good to have very low levels of sexual harassment, but today one of the key duties of an employer is to create the system to handle and tackle sexual harassment at the workplace and to comply with the law. So whether the number of instances are high or low, he is not really going, he cannot be, targeting that we should have very low amounts of sexual harassment, because that might lead to some kinds of unethical practices such as suppressing complaints, encouraging people to, not complain. So we do not suggest that at any point. We are only suggesting that, if you are complying well with the law, maybe sometime, sexual harassment instances may die down. But it may also happen initially that you see there is a huge surge in the number of complaints that are reported as employees get more comfortable with reporting. There could be any pattern there, but that does not reflect your status with respect to compliance. That is one.
No, not at all. Not at all. That's a clarification, and allow me to just make a point here.
Sure.
We're discussing today what is the requirement for this law and what are employers required to do. This is this is also a platform for understanding for a corporation. There have been many reactions to this law which are readily available from the media and from social media sites, which have ranged from applauding this law to in fact creating a fear of not wanting to hire women employees. Of course, applauding the law is a very great thing, that as it will encourage a better workspace, and not encouraging women employees also is a impractical outlook. The more practical outlook is in fact to try to create a workplace mechanism that, as you rightly said, encourages a complaint mechanism. It's not the statistics of not having complaints. It's the statistics of having, in fact, when we mention companies like Motorola, General Electric, and large worldwide corporations that have lower incidences of not just sexual harassment but other compliance with the law, is because companies are looking, in fact, at treating compliance and governance measures that are mandated upon them by legislature as something that will, in fact, encourage a more equitable and productive workspace. An equitable and productive workspace is not created out of fear. It is created out of, in fact, having a compliance mechanism that has the right tools at it. The right tools have been mandated here in a very simplistic format, yes. There are many rules, there are many experts available to, in fact, interpret those rules for these corporations. There are experts in, as we have already discussed, in a variety of roles that can interpret these rules for the corporations and help a corporation to, in fact, have a policy, a mechanism, an internal complaints committee, good training, and good notification, where over time, initially there may be more complaints, or initially the impact of the training that is imparted will allow people to understand what in fact is allowed and in fact is not allowed. One of the largest reasons is society has not prepared people for understanding what is in fact allowed and not allowed in social interaction between men and women in a workplace. So the idea is not in fact to take down the incidence of it, but to understand from good examples that having good policy, good committees, good training, and in fact putting these together not just with the outlook of ticking the box, but in fact with the outlook of creating an environment that then automates itself and allows issues to be resolved at a level where they ought to be resolved before they are heightened. At this point, I'd like to point out to you there was a very large instance, a very large media case of the Tehelka case last year, which led to a criminal investigation and in fact a much larger inquiry, and unfortunately has led to the downfall of an entire corporation. Now, had there been a committee in that instance with the correct information and the correct training, then the training would have allowed an employee to understand what they needed to be subject to and not subject to. The information and the comfort of having a confidential complaint mechanism would have allowed any employee to be able to first complain in an instance, to understand or at least complain of whether an act actually amounts to harassment or not, and what is the position that they've been put in, so that it can actually be taken care of and addressed at an internal level. Thereafter, of course, the mechanism of the complaints committee would determine the fairness of the inquiry, the investigation, the verdict, the punishment, and would not lead to an entire organization facing bad publicity, terrible optics, in fact, breakdown of the daily working and environment of the company, and the company almost shutting down and losing its apart from losing its productivity, losing its place in the corporate and the media world, only on account of not having a procedure that in fact serves to address an issue at the time that it needs to be addressed and in a manner in which it ought to be addressed. And that was the intention of being able to provide these committees. Okay, I think if that answers your question, of course, the training of ICC members is a challenge, and finding a good trainer will help a company address issues or that may or may not arise in time to come. So along with having inherent issues of being compliant with this law, I think companies should look ahead and not have issues that will be around the manner in which a complaints committee is conducting investigations or the formation of a complaints committee.
Yeah, some of the challenges or issues that need to be tackled when there is any capacity building exercise for the ICC are discussed, are actually on the screen. Now the idea is that this is very exhaustive training, and a lot of times in-house legal departments or company secretaries or accountants who are typically entrusted with these kinds of activities, they will do well to actually take outside assistance where it is easily available, because every company does not individually need to reinvent the wheel and start building capacity from scratch. There can be something outside, like for example, iPleaders has a technology-enabled solution which provides some handy formats, videos, and technology-enabled training for cloud-based compliance. So these kind of solutions are available which can be attempted. So the goal is that any training should address these 8 issues which are on screen at least.
I am in agreement with you that the more exposure that you give to the committee in whom you are entrusting an internal complaints mechanism is a very worthwhile investment for any corporation to undertake. Getting varied levels of expertise may or may not be required by companies depending on their own sizes, but enabling their own members to be in fact able to address issues, this being a specific human relations issue and a human relations issue that is squarely covered by the law, it is worthwhile a corporation in fact investing in setting up a system that is conducive to allow this mechanism to work. So the rules can be created, rules are created. We as experts create these rules for corporations that request, and we request expertise on this matter. And as trainers, we train companies to be able to have the appropriate notification method, investigation method for the ICCs. However, for a company to have its own inherent in-house ability and keep refreshing that and training up people that in fact have long-standing associations with the company is worthwhile for a corporation.
All right.
I think
let's move on to the next. This we have discussed, some kind of systems that should be set up by employers. Do you have any specific examples to substantiate this, to explain this? Because it's quite confusing, when an employer is already faced with so many responsibilities, he doesn't know how to discharge it. Okay, and how should the, for example, system to prevent retaliation against complainants. Okay, any woman who complains at the time can get justice, and then later on you realize that, maybe something has happened, she has been fired on some ground later on after maybe a year.
Well, to be honest, there is no rule around how to create this. Although I have at least on 4 or 5 occasions in this presentation itself insisted on a comprehensive policy, I would also caution corporations, that's why, to invest in a good policy that actually squarely addresses the issues that that company has. That a policy cannot address every kind of issue is, one, not only is it obvious, two, on the square point of retaliation, it wouldn't, I've had experience in this, it doesn't benefit a company to in fact have a policy. To have a generic policy of anti-retaliation is correct, which is, it's the appropriate thing for a company to let its employees know that we do not engage in retaliatory measures because that is our policy. However, after a certain period of time, there should be or would be a sufficient reason for an employee to be removed from their position. If there is a reason outside of just a retaliatory measure, then a company has its own reason for it. If the person, if the complainant or the victim or the accused, any of those three, is in fact a productive and important member of the workforce, an employer would not usually in fact find reason to remove that person. I've had experience where in fact despite a complaint and despite a very uncomfortable position, which unfortunately was not contained, not owing to the organization but owing to the employees themselves, the confidentiality was not complained, the company in fact managed to retain all the employees because it was productive, and in fact the nature of harassment or overstepping the mark allowed them to train further people and use that as an example, and the employees did not have any issues in being used as an example since people are not aware of the nuances of this issue. So if they're not aware of what amounts to sexual harassment, a complaint can sometimes in fact serve as an example, and it's not necessarily a bad example. And that nobody was thrown out of the, there were no measures or retaliatory measures. That is again the position of a company. Why would a company in fact remove a very productive, very essential employee on account of a retaliatory measure? They would have other good reason for it. A committee in fact makes sure that you don't remove employees on account of sexual harassment when you actually have other reasons and you can't find reasons to remove them. And there have been cases in the US where there have been highly public cases, and now there are more and more public cases in India, and we will possibly get more experience out of these cases as to how to deal with an issue. But to provide that, and the rules may not to provide that you will not be retaliatory is highly advisable, but to actually form parameters for it may not be possible. because there can be
Alright.
very many reasons. But I think a company will always have a cooling off period. In its regular compliance policies, it will have a cooling off period before which it wouldn't allow for anyone to be removed from their jobs.
Okay.
Hmm.
A cooling off period where, you know, there is
You see,
a
yeah,
freeze on maybe termination and
exactly. And I think
okay.
depending on the nature of the complaint, depending on whether you're actually in fact the victim or the perpetrator of a complaint, you will, in order to be able to resume good working relations, find your own space. In most instances, there are cases of transfer. Whereas there's no case of transfer, see, if a sexual harassment case in fact amounts to a criminal case, somebody will, the victim will mostly use the criminal route. Harassment mostly covers areas which are nuanced areas. They don't usually cover areas, and I'm saying this not loosely but very carefully, they don't usually cover areas that actually amount to crimes against women, which are crimes of violence, including, not only limited to, rape. They in fact are harassment of more nuance, of remarks, of manners, of empty threats of losing your job, and those are the instances that are greatly going to be actually addressed by the sexual harassment policy and the law. I hope that answers your question.
Yeah.
Okay.
Okay, the last part of this is related to sensitization related challenges, especially with respect to, you know, training of employees. Conventional sensitization methods would only, you know, they would be physical, only classroom based and live, and, you know, very few employees could be taught at once, and it was very difficult to reach large every part of a large organization, especially if they employed contract workers. So these continue to remain very important, you know, problems which need to be fixed. And other such problems are, you know, when you are actually training, sensitizing employees on sexual harassment laws, there can always be an animosity or, you know, a sense of suspicion between members of both the sexes, where, you know, they will be uncertain as to whether certain kinds of conduct is going to be viewed well by their women colleagues or not. And so it is very important that this training is carried out in the correct form and mechanism, and employees should have access to it as and when they need it, because, you know, you might have been trained at the time of induction, but 4 months down the line, when there is an incident which you want to understand whether it could qualify as sexual harassment or not, you know, where you're feeling uncomfortable about it, that's when you need to have ready access to the same form of training. You know, just having a piecemeal sort of access cannot be good enough, or sometimes it is difficult to recollect these things from memory, you know, every time. So these are some challenges that exist in the that need to be tackled by employers. These are possible, of course, we think, through technology implemented solutions. Yes, Shibani, please.
No, I'm so sorry.
No. So I am done on that. Yeah.
In fact, on one of the challenges, what we have addressed in large corporations is before the internet there was the LAN, and one of the methods in which things that are of relevance, compliance rules, standing orders, policies such as awareness campaigns, such as, especially for sexual harassment, which is something that is new, should be available to the employees for their reference, which is why employers would be best placed to in fact have policies for employees that are informative, that are clarificatory, and that are available and accessible, so that employees do not either misuse them or underuse them. One of the best methods is technology-enabled training. For years, for the last 20 years, most of the international organizations that have in fact been able to train employees on a sustained ongoing basis have been technology-enabled trainings. Also, especially working in India, there are a number of organizations that are in fact receiving this training today, and they would have different challenges. And of course, I want to welcome questions on those challenges themselves, which are, as we look in India, geographically we have challenges, industry-wise we have challenges from the introduction of women in a non-conventional workspace. and how you actually want to address that training. We have been asked sometimes that we only want to have a trainer that's a woman because currently it's a non-conventional workspace so that they can understand this better. I feel technology addresses a lot of these challenges of being able to access more people, to be able to provide them. So you have a lot of companies today have an intranet. All advanced companies that have an intranet have most of their compliance policies available in it. And it's interesting, but my personal observation is that companies which are giving access to more employees are in fact not inviting more complaints, as in more invalid complaints, but in fact valid complaints and valid issues which are helping companies tackle these issues at the outset rather than at a very advanced stage. So I think technology, constant training, repetition of training, availability of the basic tenets of the training, what amounts to harassment, who can you complain to, should you speak to somebody, the fact that this is confidential, the confidentiality is a very important thing. It will take us some time to understand that. We as a society have not totally understood and appreciated confidentiality and privacy, but we are learning to now for the fallout. So all these being available from a technology-based training is a very important and relevant advancement today. Sorry. I think there's also this, there are ways by having a proactive, protective policy and a good training, you will encourage a culture where sexual harassment is in fact reported. It's in fact reported. If you maintain confidentiality, it will be reported. It will be reported not necessarily at every instance to actually have a punishment, but many instances of report allow an issue to surface, allow that, in that industry, there are more instances of potentially either having harassment or having the misinterpretation of harassment, and then being able to in fact address that and informing your employees ahead of time that, so for instance, if you have work timings or transport mechanisms, companies are now looking into these transport mechanisms because they are trying to create platforms which do not have more instances of harassment, but less instances of harassment and less incidences that amount to probably criminal versions of harassment.
Right.
Yeah.
So Sibani, we will, that brings us to the close of this session. There are, at the end, I would just, before I hand over to Mithali, I would just like to, put in a small piece for the sake of information of all the participants, that there is a technology implemented compliance toolbox which is available to them in case they would like to sensitize employees through internet-based training and provide access to training materials online on their mobile phones and computers, and which also has certain kinds of formats and decision-making guides, copy sample orders for the ICC, formats of annual reports. All these components are available on a cloud-based toolbox. In case anyone is interested in inquiring about it, they can write to us on the email address given at the bottom of the screen, that is esh@ipleaders.in. And in case they also have questions pertaining to the webinar conducted today, they could still write to us at that email ID, or they could even contact CII, which will forward us the questions. Siboni, there were just 3 very short questions that had been asked over the course of this session, so we will just go through them. One question was whether a witness can refuse to present himself for an inquiry in case of a summons.
So currently, we are not subject. So fortunately, sorry, should I answer that question first?
Yeah, sure.
Yeah. Okay. So fortunately, at some level, internal complaints committees do not have the power of the criminal justice system to, in fact, summon somebody. So it doesn't have other criminal justice system advantages either. However, you're required to conduct the inquiry. Now, an employee can refuse to attend, and employees have refused to attend. So then the burden becomes on the committee to in fact collect that evidence in the absence of an employee. However, in actuality, a company itself can require in its own standing orders employees to be cooperative. So where there is an issue which is fundamental, when you start looking at sexual harassment as and a culture of compliance as underlining a corporation, then companies are allowed to expect from their employees, if just like if there was a case of theft, an employee